What a moot court problem does is it does focus students on one or two legal issues. And then they do their own research. And they have to figure out how does this particular legal question, how does it track over time in our legal history? Is it different in the states or the federal system? Is it evolving? Has it changed? Are we asking something new right now? Or are we looking at maintaining a tradition that has occurred over time? So in the beginning of the preparation, what you tend to see from students is they have an argument, it's pretty well written out, and they want to get through all of the steps, and they want to do it in a certain sequence because it makes sense. And so then once the first team goes up, they have the opportunity to make their points and pitch their case to the panel. And then the other team gets a chance to sort of rebut and also make their own case. The panel represents what would be a typical sort of federal panel with 3 judges. And in most instances, and here at Lewis and Clark, it represents 3 faculty members. So in this particular case, we have a question about whether animals are defined, include chickens, which is kind of an interesting and unusual question. And the second question is a more sort of esoteric, theoretical, legal conversation about preemption.
They have under Title IX, Chapter 1, Subchapter C, which covers the interstate transportation of animals, quote, including poultry, in parentheses, laid out first the feeding requirements for animals under the statute. And they've listed out particular species, cattle, sheep, swine, goats, horses, and mules.
You might have heard of the Socratic method. Some judges sort of use the Socratic method by asking a question. It really prompts the students to think about, oh, I hadn't really thought about it in that way.
Your interpretation of the statute actually seems to make it absurd. I mean, on its face, animals sure includes chickens, but now you're suggesting any animal goes. It just doesn't, it seems like Congress has to have drawn a line somewhere, and it drew it at those animals that it actually listed in the definition of animals, right?
Congress did draw a line, but it wasn't with the term animals. The statute itself, we can look to the plain language of the statute.
So animal law really brings into sharp contrast the questions about what does contract law, what does property law mean, all of those things. And it really forces students to think very, very deeply. And they do much of this work on their own and in teams, which is a wonderful thing. So they're able to synthesize and integrate much of what they've already learned in the classroom, but bring it to a much higher and richer level through the competition research process. And the idea is that after we do all of these 20 rounds and have a number of judges, that the students will be exposed to pretty much most of the kinds of questions that they're going to be faced with during the competition. Now, there'll always be something new, but they get much more comfortable handling the questions, and there are fewer that are outside the parameter of their experience, and that's the idea. Students don't have the opportunity to engage in a really intensive way, both in substantive legal matters sometimes, and also in developing their oral advocacy skills. So moot court gives students an opportunity to do both of those things, and with faculty support, generally speaking, and additional student support. So in addition to giving students general advice about how to proceed or think about the laws, or just question the choices that the students are making to get them to think more deeply about it, just the exposure over time to all those kinds of questions is a very valuable thing for the students.